Good morning. In continuation of the last lecture on international family law, we now proceed for the teacher and the taught. Two very interesting issues pertaining to children. And as far as the laws in India are concerned, particularly those which have either through the courts or through parliament evolved a new jurisprudence of a creative child rights jurisprudence. The first topic in the context of promotion of the welfare of the children is adoptions, and the second is the topic of surrogacy, which has been the subject of two acts of parliament which have been passed in 2022. But first, a brief background. India signed the United Nations Convention on the Rights of the Child in 1993, and pursuant thereto, India was obliged to make statutory laws incorporating the beneficial provisions of the convention, focusing on the rights of children. And among these were very important rights relating to the rights of the child to a family, to a home, to a nationality, to a citizenship, and above all, a peaceful and congenial atmosphere, as also a right to find a home through adoption if need be. Faced in this perspective, we have seen very recent developments in the law of adoptions. But first, these three successive Supreme Court judgments in Lakshmikant Pandey, 1, 2, and 3, spanning over a period of 10 years from 1984 onwards, saw a sea change in the law of adoptions and its evolution by court created precedents. The Supreme Court stressed the need for a statutory framework for the matter of adoptions because there was a very serious problem in trafficking of children overseas, and children were sold or abused and exploited in foreign jurisdictions. Due to the efforts of the Supreme Court, there came about an administrative body called the Central Adoption Resource Agency under the Ministry of Women and Child Development. But then, the Juvenile Justice Care and Protection of Children Act, initially the 1986 version, then the 2012 version, and ultimately the 2015 version, saw a complete new, overhauled, evaluated JJ Act for short, in which there was a complete chapter on adoptions, both intra-country and inter-country. Now, the basic philosophy of the UNCRC that children must be socially reintegrated with society brought about this beneficial change because 12 million orphan children were at the hands of very dubious and surreptitious methods, and therefore a statutory framework came about by creating now Central Adoption Resource Authority, a statutory body which, in pursuant to the signing of the United Nations Adoption Convention of 1993 2003 subsequently, led about India to create a statutory framework for inter-country and intra-country adoptions as per international standards. So came the rules under the JJ Act and Adoption Regulations 2017, which created a streamlined procedure in matter of inter-country adoptions, whereby any person in any country of the world could adopt an Indian child irrespective of marital status. Now, this was a very crucial development because there were no barriers of adoptions as far as foreigners is concerned. But at the same time, there was a very dynamic interpretation by the Supreme Court, and the Supreme Court held that the JJ Act is a secular law, and therefore anybody could adopt under the Juvenile Justice Act, and extended the benefit to the Muslim religion also. So Hindus could have adopt under the Hindu Adoption and Maintenance Act 1956, but also Hindus could adopt under the Juvenile Justice Act. So the secular law being available and the personal law being available, there was a choice. But coming back to the process of inter-country adoptions, the adoptions through the Kara came to be established, whereby anybody who could wish to adopt domestically or internationally would get on a registration under a system called carings of the Kara, and as per the weighting would be processed in the country of their origin by Kara equivalent or authority equivalent in that country, and upon their suitability for a child to be adopted in India, their particulars would be exchanged, the child would be matched, they would be offered the child, they would go and visit the child. This would be followed by evaluation report. Ultimately, it would lead to Kara granting an NOC, and then formally an adoption order by a court, and thereafter the Kara granting an NOC finally, or a conformity certificate that the adoption is in conformity with the adoption convention, and the child would thereafter be permitted to leave the country with the adoptive parents. So this streamlined process fell into a complete workable system, and though it is criticized for being slow, but there is a process by which this process is now at least streamlined. And to expedite in the process of adoption, in their wisdom, the Women and Child Development Ministry has given the assignment of the adoption order being issued by executive authority instead of a judicial court. I would think that that is not a good idea, even though it is criticized for being causing delay. But giving an administrative authority the screening of an adoption, which is the prerogative of a judicial court under the Guardian and Wards Act and other legislations, is perhaps not a good idea. That being so, there was again an anomaly in this process, that inter-country adoptions under the HAMA, that is the Hindu Adoption and Maintenance Act, came up for interpretation in two different cases in the Punjab and Haryana High Court, and I had the benefit of assisting the court as an amicus. And there the question fell whether an adoption under HAMA would require an NOC from Kara. Now, in that perspective, there was a freedom under the Supreme Court judgment of Shabnam Hashmi for Hindus to adopt under the JJ Act and to adopt under the HAMA. So if there was an adoption under HAMA, the requirement of an NOC from Kara stemmed from the Hague Convention on Adoption signed by India and not under the JJ Act. So therefore, the requirement by reading into the rules was that the adoptive parents would apply after the HAMA adoption to Kara, and Kara would get it confirmed, and Kara would issue a conformity certificate confirming that the adoption has taken place in accordance with the process prescribed under the Adoption Convention. Now, adoptions under HAMA are governed by a process of giving and taking. A formal ceremony of Datta Homan is all that is needed. No writing, no registration, no recording. Though it is said under HAMA that if there is a process of giving and taking, no recording is necessary, and in that context, the requirement of the ceremony is sufficient and will confirm to the process. But then, the provisions of the JJ Act Section 56 say that all adoptions under HAMA are exempt. But at the same time, in Section 56 and 60, it is said that all adoptions made inter-country shall abide by the procedure prescribed under the JJ Act. So there was an anomaly, and the Delhi High Court thereupon called upon Kara to streamline this process, and ultimately, upon a judgment rendered by the Delhi High Court in 2022, the adoption regulations have been amended, and there is now a procedure prescribed under the adoption regulations 2022 amended as they stand, whereby adoptions which have been made under Hama are now administratively processed through a process in the regulations, and upon verification, conformity certificate issued by Kara. Now, the necessity of a conformity certificate greatly helps, because without a conformity certificate whereby it can be confirmed that the adoption convention's requirements have been met with, the child will not be able to get a visa to leave the country, because no embassy of any country will give a visa to a child to leave the country unless there is a conformity certificate issued by Kara, that is the central authority of the country. So this is how broadly the process of inter-country adoptions has been streamlined, and a complete workable system has fallen into place in this process. Now, at the same time, there has been a lot of discrepancy and a lot of thought process being developing in the matter of another issue relating to the whereby parties can have children, and that is the controversial topic relating to surrogacy. So, surrogacy developed as an alternative to having procreation of children when children could not be born naturally to parents. Now, in this perspective, the issues relating to surrogacy came about in 2005 when the ICMR made administrative regulations or guidelines, and whereby surrogacy very quietly was permitted through approvals granted by these administrative guidelines. And in this process, surrogacy became a rampant and flourishing practice among large number of Indians and also foreigners, and it ultimately developed with commercial overtones, and it went on till about 2012 when foreigners were required to obtain medical visas for the purposes of coming into India for surrogacy. Then there were some mishaps when children born out of surrogacy were abandoned, and ultimately by 2015, surrogacy for foreigners was disallowed in India. At the same time, the Surrogacy Regulation Bill and the Artificial Reproductive Technology Bill came about. The first ones came in 2010, then 2012, then 2015. They were referred to various parliamentary committees from time to time, and ultimately, with suggestions coming forth on different views on surrogacy, we have seen that both these laws, that is the Artificial Reproductive Technology Act 2022 and the Surrogacy Regulation Act 2022, have come into force. Now, from a permissive commercial rampant surrogacy practice in 2005, today commercial surrogacy has been banned. Only altruistic surrogacy to help a person is available. It can also be called compensated surrogacy in terms of giving medical expenses and care and look after expenses. Surrogacy is no longer available to foreigners, though OCIs, that is overseas citizens of India, are permitted to entertain or have surrogacy. it is confined to married couples with 5 years of marriage and proof of medical inability to have children. The surrogate has to be a close family relative or a known person. Reasonable compensation or medical expenses are paid. A woman who's a surrogate can only be a married woman who has children of her own, and the age of persons entering into surrogacy have been prescribed. So this new law of regulated surrogacy has come up for criticism for the simple reason that when it comes to procreation, the vibrant views of the Supreme Court under Article 21, that is right to life, mean the right of life means the right of procreation and the right of reproductive autonomy. So, if by reasons of reproductive autonomy I am permitted to procreate, then it is my choice how I want to procreate. The state cannot define limits. The state cannot provide regulations. The state cannot provide restrictions. It is in that perspective that the right to procreate has to be an independent right. So is the right to life of practitioners, of surrogates, or meaning a right of livelihood. As also, it is criticized that when I have an achievement of a means of parenthood by adoption, I am permitted to adopt irrespective of marital status. So, therefore, why in the matter of surrogacy, which is also a means of achieving parenthood, am I given a restriction upon me that I should only be an Indian or a person of Indian origin? I should be married. And why is marital status coming in the way of surrogacy? So the broader issue is that in a time when we have a 9-judge enlightened Supreme Court bench judgment of Puttaswamy's case of right of privacy and which is encompassing all my rights and privileges as a person, why is there a restrictive practice of the state in confining surrogacy only to married couples? Why not single persons? Why not persons in the LGBTQIA category? Why not surrogacy for foreigners? So, if Article 14 and Article 21 are available to persons, unlike Article 19 available to citizens, is this restriction a valid restriction? Is it with an object sought to be achieved? Is it a reasonable classification? Are all questions which have come up and will be tested once these laws, maybe if they are questioned, will be determined by the Supreme Court in an appropriate petition, in an appropriate case, as and when they come up. But at the same time, the regulation of surrogacy in this manner may create a lot of confusion. Now, if there are questions pertaining to nationality, pertaining to parentage, pertaining to citizenship, pertaining to right of a surrogate child to know his parents, are our courts prepared to handle these critical issues? Are our law pupils, our law teachers equipped to know and learn all about adoption and surrogacy, which I have just talked in the past over 18 minutes? Is this information knowledge taught? Are these subjects available for textbook reading? The answer is no. I happen to teach these subjects at Symbiosis International University in Pune. I have been giving lectures online even all during the pandemic. But I seriously think that in today's times, teachers, law pupils must be equipped with these latest inputs on issues of adoption and surrogacy, because they are a very pivotal point of development of child rights jurisprudence and human rights, as also rights of individuals, from a perspective of international family law, which we would call private international law. But since they are very much conjoined with domestic laws. Therefore, an understanding of these laws in conventional family law issues is extremely important, and it is at this juncture that I impress upon law teachers that you have to be update by whatever material you use, maybe reading, maybe discussing judgments, maybe public lectures, or maybe even moot court competitions to equip students to come up to learn these subjects, which are going to be very, very important in a developing world. The Hague Conference on Private and International Law is also already looking at projects on parentage and surrogacy. And at the rate at which we are going, we may perhaps need an international law on surrogacy, because surrogacy involves different countries and laws of different nations. When commercial surrogacy was banned in India, it shifted to Nepal. There was an earthquake in Nepal and it shifted to Thailand. From Thailand, it went to other countries like Bangkok and smaller nations. It landed in Vietnam. But then, ultimately, a totally unexpected situation came about in Ukraine. Now, Ukraine was a country which permitted commercial surrogacy. There were websites of foreign agencies which showed you different packages starting from 20,000 euros to going up to 80,000 euros, offering you different kind of facilities in so far as surrogacy was concerned. You needed to go to Ukraine to have services of a surrogate available. Sperms and ovum banks were also there in case your genetic material was not enough to sufficient. And then the surrogate baby would be born. And upon identification, you would be allowed to take the surrogate child out of Ukraine. But then when the war broke out, 500 odd pregnant women in various stages of carrying the surrogate babies and children born were left clueless in what to do. I came across a news report in the New York Times, which I later developed into an article, that there were at least 100 babies in a bunker, in different bunkers and in different underground places, being looked after by nurses and nannies, because no parents had come up to claim these babies. And unless under the laws of Ukraine they were identified and genetically confirmed of parentage, they could not be taken out of the country. Now, how would you resolve the issue in a situation like this? Obviously, I advocated that the International Red Cross is to step in. Maybe a team of the UN Hague Conference on Private International Law has to intervene. A safe corridor has to be provided. A confirmation, maybe in a neutral country, Poland or Russia's borders, would be made available where the babies could be transported. Their parents could be facilitated to enter. Their identities could be confirmed, and the babies would find way home. So, the bottom line is that times create awkward situations and they require very different solutions out of the box. Are our domestic laws in India geared to handle these situations? The answer is no. Most of our laws are outmoded. We have not changed them. But with a 30 million corpus of Indians living in about 180 to 200 countries abroad, our migratory population brings in and out a lot of family law issues which defy domestic laws because they are outmoded. So our courts do a very difficult task in solving these problems, and in Indian constitutional courts perform a Herculean role in providing out-of-box solutions. May it be child abduction, may it be surrogacy, as we saw in baby Manji Amda's case, or in the German children John Bala's case, whereby children were taken out, though they were born out of surrogacy, by orders of the Supreme Court through assistance of an adoption process or an informal process, and were made to leave the country. But then, are these out-of-box solutions the answer? No, obviously. I am also reminded of baby Emperor's case in Hyderabad, whereby a woman based in the US had brought her frozen embryo in a cryogenic jar because her husband, a Jamaican husband, suffered from aerophobia. He couldn't fly. Now, the genetic material had been contributed by her husband and a surrogate, and the baby was born in Hyderabad. When the baby was born, the passport officer declined to issue a passport to the child, stating that the mother's genetic material could not match with the surrogate, with the child born to the surrogate. So she kept on moving up and down the passport office for a month or so, and ultimately she left the baby on the passport officer's table and said, "You keep the baby." Now that triggered off a reaction, and the child was given an emergency travel document to leave the country. Is time going to answer these questions through our laws? Time will tell. Time will only tell if our students and our law teachers are equipped to handle these questions, and their minds are engineered and made knowledgeable to answer these questions. Thank you very much.